I'll just go back to praising Shrina first to say that not only does she give the question, but she gives part of the answer as a cue. So it happened in the first, and now, of course, this is the second. But after having heard Gaurav on the subject, and really, I keep wondering, how have we done this entire practice of having a provision of law which provides for something, and we've interpreted it completely reverse. So for me, the day is staged as reverse engineering. Now we have to go into that process somewhere. There are two ways possible. And what kind of a process may be done is one, the substantive correction. Gaurav pointed out rightly that it may go to a 7-judge if it so happens. The alternative is legislative amendment. But legislative amendment would be strange. The law actually says you don't have to prove actual loss and damages, but nonetheless, we are able to do it when we want to. So I think explanations could be added very validly to take it out of the circuit of this entire trajectory of litigation as it goes along, because now we are dealing with Commercial Courts Act. We are dealing with the entire process of med. We are dealing with resolving disputes in the fastest possible way, efficiency, and what have you. Now we need to get our substantive course corrected for the reason that if you have a provision which is amenable to a certain construction, that construction is always going to happen. And that construction today unreasonable, the quantum, what it should be, is really a question in the open. To come back to one of Shrina's questions to say, should it be what? So I come back reverse engineering. It should be presumed liquidated damages is actual, whatever is discussed. We don't have the time or energy now to dispute all these issues time and again in various jurisdictions. We just have to stop somewhere. And commercial efficacy demands that you actually give or you get what you committed to. The commitment reduces the uncertainty, the time gap, the processes, and then ensures that you don't want to take advantage of delay. Everybody knows that you actually work on delay as a system, so you want to reduce that. So reverse engineering, yes, Shrina, the test of what it might be would actually be that the liquidated damages stand, except where they are disproportionate or onerous, and whether we review it by the 7-judge bench or the 9-judge bench, or we do it legislatively, it's high time we do it, because we are working on Viksit Bharat, 4th largest economy, FDIs, everything else that we have to go with us. If we can't reduce our ease of doing business, and we're not very, very high up on that, we've improved, but that index has to go up. And the only way to improve the index is to reduce uncertainty, vagueness, ambiguities, and to make it clear. So what was clear has to come back in one way or the other. The earlier regime actually also, I will add to what Gaurav said, worked on a socialist pattern of thought. That rescue, the David and the Goliath fight. In 1872, save the poor people, don't put them to terms. But today we are not in that circuit. We have far exceeded into a Viksit Bharat, as I said. So today you have people who are of equal strength. The bargaining positions are somewhat equal. Of course, there'll be always some inequalities, but at the same time, you have mostly equal bargaining strength. So reduce it, make it certain, have liquidated damages stand where it must and should, and only reverse it in the case of where it is possibly disproportionate. And the proportionality test has been used in US very well, in fact, as a criteria to do so. I think we can take examples from wherever, and we sit together and take this up to its logical conclusion.